Buddy, my name is Kathleen. It's actually Hayes now. I just so I am an attorney with Disability Planning Partners. We have an office in Hartford, Connecticut. And Carmina asked me to speak today on decision-making options for individuals once they turn age 18. And the reason that this topic, I think, is garnering a lot of notoriety and attention statewide and in terms of discussion topics right now is because supported decision-making is a new decision-making tool for individuals really with or without disabilities when they turn age 18 and become a legal adult. It's another option to throw in the toolbox in terms of how to make decisions when someone's a legal adult if they need on. So I'm going to get started.
Yep.
Go to the next slide. Okay, perfect. So 18 is a magic number in the eyes of the law because it creates a legal barrier between parents and children in terms of their ability to make decisions. So before age 18, parents are the natural guardians. They can make decisions about healthcare, education, finances, really anything. Until that age of 18, there is a presumption that no matter your cognitive ability or your maturity level, that by default, you have the ability to make all of your own decisions. And I have two little symbols here. The heart is for health and medical decisions, and the dollars are for financial decisions. So this creates a bit of an issue and a quandary, and usually comes up, I think as Kevin can speak to, within the educational setting so often when a child is turning age 18 and the school often says you need guardianship. And so the part of the focus here is to give you an idea of the other options that are available, that guardianship is not the only way to help to continue supporting somebody's decisions past at age 18 and beyond. So I've broken this presentation into decision-making for health and well-being and decision-making for finances because those are the main topics covered by different legal decision-making tools. And I often find that the terms for health documents are often conflated and confused with the terms for financial documents. So I really wanted to set these up separately so that maybe people can organize them in their proper quadrants. So here's the spectrum as I see it. And I call this a spectrum because the different legal tools that are available range from least restrictive to most restrictive options. And what I mean by restrictive is that we're looking at who's in the driver's seat and who's in charge of making a decision. So the least restrictive options are advanced directives, supported decision-making agreements, and as we move along, we become more restrictive with conservatorship, voluntary and involuntary, and guardianship. And the shift is really who's making that decision. For an advanced directive, the individual remains in the driver's seat, and all the way on the other side of the spectrum, parents or other individuals are in the driver's seat making a decision on behalf of somebody else. Visually speaking, as you look, I try to keep this visual representation on the other slides. And if you notice one person icon, that's really focusing on who is creating the agreement. And so that's meant to represent the individual with a disability is actually choosing and creating the agreement or the legal document. And when there's two individuals, it's other people are initiating this process. So we're going to take each one in turn. We're starting off with an advanced directive. So an advanced directive is a legal document that is created by the individual. And I get a lot of questions as to the threshold for capacity to enter into or create an advanced directive, especially from parents who are considering different options and they're really not sure whether or not their son or daughter has the ability to create an advanced directive. That's really my job to determine, because whenever I am taking somebody's oath or they're signing a document in my presence, I have to confirm that they're able to understand the nature of the document and they're able to express their wishes about healthcare decisions and what the document really says. So what that looks like for me is, okay, this is a document that has to do with medical decisions. Do you understand? If the individual can express that they understand what that means, I feel comfortable. And I go through each of the provisions of the document and check in and ask some open-ended questions to make sure that the individual's understanding generally what the document covers. They don't have to be able to understand every legalese, as many people don't. And that's okay as long as they understand the overarching concept of each provision. And I'll say, and who do you want to make decisions on your behalf? And a lot of times they'll say, well, my mom and dad. Do you trust your mom and dad? Yes. If an individual can answer all of those questions and I feel confident, even in the absence of the parents, I often ask them to step out, that these are their decisions and that I feel comfortable that they understand the nature of them, then they can create this document. So how does it work? There's a couple of different provisions in an advance directive, but the primary focus is that you're naming a healthcare representative. You are naming somebody else to step in and make decisions relative to your healthcare needs in the event that you lack capacity and you're not able to make those decisions yourself, or in the event that you want to welcome other people into the decision-making process. So what that looks like, for example, would be somebody going into a doctor's office and instead of the doctor saying, I'm sorry, mom or dad, you can't come in, the individual would say, no, they're my healthcare representative. I want to include them and even potentially defer to some decision-making that might come up as part of that appointment or their overall healthcare planning. I recommend that any individual who has the ability to enter into this document cognitively create it, disability or not, when they're age 18, because this document survives incapacity. So what that means is that I've created an advance directive. I name my husband, and then I might name a sibling, for example, as a backup. If I go outside and a tree limb falls on me and I no longer have the capacity to make decisions, my husband can step in and make those decisions for me, as opposed to having to go into court and have the court choose somebody else for me. So it gives you that ability to plan for yourself now and plan for yourself in the future should you lose capacity. It's also an important document, for example, in elder law planning where somebody might have a dementia or due to age is really unable to engage in their own understanding of their medical conditions as maybe they used to be able to. Whose wishes win? So this is really critical. The individual's wishes win if there's a disagreement. So by creating an advance directive, you're not giving up your right to make your own medical decisions. You're simply giving other people authority to weigh in on those decisions if you ask them to and if you want them to. If I welcomed my husband into a doctor's appointment and he said, I want you to have the surgery, and I said, no, I don't, then my wishes are ultimately always going to win. Feel free to ask questions as well, just chime on in. Okay, so the next stop along the spectrum of decision-making is supported decision-making. So supported decision-making is a new legal concept within Connecticut, but it's not new nationwide. There are a handful of states, Texas, Arkansas, Delaware, I forget all the states, but a handful of states that have actually enacted supported decision-making in their laws, meaning that they have laws that say this is what a supported decision-making agreement is, and this is how it works. Within Connecticut, we're starting a task force coalition, or we have one up and going, comprised of various stakeholders, individuals with disabilities, different organizations that serve individuals with disabilities, the Department of Education, Department of Developmental Services, various agencies, service providers, and all of these individuals are coming together to say, we think this is a great idea. How do we spread education about this? And that's really what we're doing. We're putting together a toolkit of information for organizations and individuals in terms of what supported decision-making is and how it works, and ultimately potentially pushing through the legislative process to get supported decision-making on our books. But what's important to note is that even though supported decision-making isn't in our laws, we don't need it to be in order to use it. So a supported decision-making agreement is a written document between an individual with or without a disability, really, who is naming supporters to assist them in making decisions relative to their health and well-being, finances, or really any decision in their adult life that might come up. Supported decision-making really builds on the concept of natural supports. And what I mean by that is within our own lives, we have individuals that we go to and rely upon when we have to make certain decisions. So my mom's a nurse, so I'll go to her and rely on her for medical decisions and her advice. And I'll go to my dad, who's an accountant, for financial advice. And so it's really thinking about all our sphere of natural supports. And that might mean for someone with a disability, vocational supports, educational supports, programming, social interaction or behavioral supports. So a supported decision-making agreement can be customized to the individual's specific needs in identifying what area is this person going to support me in, who am I going to name, and then providing that document to the appropriate agencies or organizations when decisions come up relative to that topic.
So you said it's not set forth in Connecticut yet, but it's a legal binding contract. Can you tell me what that means?
Sure. It basically means that we all have the ability to delegate or give authority to other people to partake in different decisions. So I can, by entering into this agreement, it's a document that I sign, it's a document that you sign, and it's witnessed. And my recommendation is that it's notarized as well. So it's a legal document where you're showing to another institution that this is my wish. I've entered into an agreement with this person and I'm asking you to honor that agreement. It may well be that because supported decision-making is so new and because there's other laws that don't necessarily recognize supported decision-making agreements, that you also have to enter into other releases as well. So for medical decisions, a HIPAA release, for educational decisions, a FERPA release, different and financial decisions as well. So you might need to support this document with other authorizations if there's other laws that might conflict.
I see. All right. Thank you.
Kathleen, I have a quick question.
Sure.
Quick question before you go to that. So the HIPAA release, don't HIPAA releases, aren't they limited? Like in terms of a year?
It depends on what you're signing. So some doctors' offices have HIPAA releases that might expire naturally, or you can enter into your own HIPAA authorization, which again is just basically citing the HIPAA laws and giving your agent or the supporter authority, indefinite authority under the HIPAA Act to access medical information.
Yeah, so what if you go to like multiple places? Like, do you have to call each one of them and give them that release so that they have it on file?
Well, so what I would recommend, and I haven't said this yet today, is that if somebody has the capacity to enter into an advance directive, they also have the capacity to enter into a supported decision-making agreement. And an advance directive should have a HIPAA release in it. And my recommendation is that if someone has a supported decision-making agreement, they also have an advance directive to make sure that you're covering those authorizations and to make sure that you have an incapacity plan. A supported decision-making agreement allows you to name supporters to support your decisions. So I'm still on the driver's seat for all of my decisions. Unlike an advance directive, if a tree limb falls on me, my supporters don't have any authority to make decisions for me. Even though I've named them, that document does not survive my incapacity, whereas an advance directive does. So there's an additional layer of protection that you get with an advance directive. And that's why I recommend that you have those documents together, as well as a power of attorney, as I'll discuss with the financial documents. So yeah, this is the Massachusetts website. Massachusetts, likewise, like Connecticut, has not formally enacted a statute with supported decision-making, but they did start a pilot program where they had individuals that were using these agreements to help educate and see how they worked. If you go, Carmina, to resources and go to, I think it's US supported decision-making laws. So these are all the states that have enacted actual statutes relative to supported decision-making. And I think you have to go back. Let me navigate to where I want to go on my end. If you would go to getting started, you'll see the SDM agreement form. Go there. And then if you keep going down, you can see a list of SDM model agreements. So you can click on any one of these. If you would go to the bottom PDF, the supported decision-making model agreements, this is kind of what we're talking about if you keep scrolling. Okay, so you can make this agreement customized to your needs, but here's a good resource for people that want to enter into these agreements for how you can draft them. My name is this, today's date is this. I want to have people who I trust to act as my supporters. If you keep scrolling, here are my supporters, you name them. And then oftentimes these agreements will have check boxes for the different types of decisions that someone might support you with. And then there's typically an other checkbox so that you can make, okay, so this one doesn't have it, but you can customize it to your specific needs. And then at the end, you're going to sign it and the supporters are going to sign it as well. So that's just an example. Okay, so I think it's helpful to kind of see what exactly we're talking about because it's such a novel concept. Okay, so the next stop along the way is voluntary conservatorship of person. The first two legal documents that we talked about, the advance directive and the supported decision-making agreement, were documents that you can enter into. My yes, likely biased recommendation is to work with an attorney to understand exactly the nature of these documents and what you're entering into, and also to give the validation that an attorney has assessed capacity at the time that these documents have been entered into, so that if anyone were to challenge the validity of the document, you'd have an attorney be able to say that, yes, I verified these things. Voluntary conservatorship of person is now the first step along the way where we're invoking the probate court. So every town, virtually every town, there's some regional probate courts. Virtually every town has a probate court, and it's based on where you reside. So for an individual with a disability who turns 18, they could choose to enter into a voluntary conservatorship of person, meaning that they could put together a form petition to their local probate court in the town or region in which they reside, saying, I don't feel ready or I don't want to make decisions relative to any of these topics. It doesn't have to be all of these topics: residence, education, employment, medical, dental, personal care, comfort and safety, and services and supports. I might just say, I don't want to make decisions about my education. Or may well be that I don't want to make decisions about any of these things right now. I am voluntarily giving that right to somebody else. So for example, my parents. I might say, I trust my parents and I'm giving them the ability to make these decisions on my behalf. So I sign this form, I name the people that I want to act as my conservators. My parents sign saying yes, or we'll accept this role. And then we go to court and the judge will make sure that I understand what I'm asking, because it's really me asking to kind of take this responsibility off of my shoulders and put it onto my conservators or my parents. And as long as the court feels satisfied that I understand what I'm doing and I want it and I trust the individuals that are named, the court will appoint my parents as my conservators. And my conservators then have all the authority that's outlined in the decree, no more and no less. So the decree might say my conservators can only make decisions about my education, which means that I retain the right to make decisions about anything and everything else under the sun, except for what's in that decree. Once the conservatorship is initiated, I'm no longer in the driver's seat. So when we talk about whose wishes win, this is the first time where my wishes as an individual don't win. The conservator gets to choose and make the final decision about any of these issues that might arise. And if I disagree, well, the court's going to say, you voluntarily gave up that right. You said you didn't want to make these decisions. So therefore, we're going to honor and validate your conservator's decision. However, I voluntarily gave up my rights, so I can write to the court, and 30 days later, I can let the court know I no longer want to be under conservatorship, and 30 days later, the conservatorship would end. So when the court creates the conservatorship, the court doesn't find that I lack legal capacity. They just find that I'm choosing to give up these rights. So that means that I can voluntarily terminate the conservatorship. There are standards of practice on the probate court website for conservators, which talk about what a conservator's role and duty is. And you'll see that there's a strong emphasis on including the individual and supporting what's in their best interest, and also supporting their autonomy to the degree that they're able to participate in these decisions. So even if my decision regarding my final decision regarding any of these items is not mine, but my conservators, the conservator still needs to really support my independence as much as possible. And that's really important, that just because you're under conservatorship doesn't mean that you've now lost all input and ability to participate in your own life and in these big decisions. The goal of any conservatorship, if it's possible, is to increase the independence of the individual, so potentially one day the conservatorship is no longer needed. All right, so one of the last stops along the way is involuntary conservatorship of person. And I put down in the little icons that it's typically an IQ of 70 or above. It can be an IQ of 69 or below as well, but I draw that line because guardianship pertains only to individuals who meet DDS's definition of intellectual disability. That's the Department of Developmental Services, which defines intellectual disability as an IQ of 69 or below. So we'll talk about guardianship in a moment, but really involuntary conservatorship of person and guardianship are two sides of the same coin, which basically means the door of entry is different because we're typically looking at your IQ. Remember, if you have an IQ of 70 or above, you can't have guardianship. So your IQ in some ways dictates which door you can walk through, but once you're through the door, the roles and responsibilities of the conservator are virtually the same. So for involuntary conservatorship of person, this is once again a court order naming somebody else to make decisions on my behalf. Now you'll see that we have the image of two individuals, not myself. So I'm not the one asking the court to implement a conservatorship. Other people are. My parents, for example, are filling out the form to the court. and setting forth all the areas where they think I still need help and assistance in my personal welfare. In order to create an involuntary conservatorship, the petitioner, the parents, need to submit a physician evaluation, which is another probate court form, from a physician who's seen me within 45 days before the probate hearing, who says, it's my medical opinion that this individual does not have the cognitive capacity to make decisions relative to their own well-being based upon medical evidence. Because when a conservatorship is involuntary, the court takes that very seriously because it is a restriction of liberty rights, just like the voluntary conservatorship, meaning that I'm no longer in the driver's seat. But unlike voluntary conservatorship, I'm not giving that up myself. Other people are taking those rights away. Because remember, the default is that I have the ability to make these decisions. So somebody else is coming in and saying, I don't think that that's the case. So the court says, all right, we take this very seriously. Number one, there's going to be a marshal that has to give you, me, the individual, notice of the hearing so that I have the ability to have an attorney. And if I don't want to choose my own attorney, or maybe I'm not able to choose my own attorney, the court will always appoint an attorney to represent my interests. And at the hearing, there has to be medical evidence that is clear and convincing. The judge has to be fully convinced that I do not have capacity to make these decisions. And presuming the judge is convinced, they would appoint conservators and in the decree specifically state what those conservators have the authority to manage on my behalf. Remember, the decree is really important because whatever the decree is silent on, the conservator doesn't have that authority. Whose wishes win here? The conservator's wishes always win, even if there's a disagreement. And that's the same as voluntary conservatorship. But unlike voluntary conservatorship, I can't just write to the court and 30 days later, the conservatorship, poof, is gone. Instead, if I want to challenge the conservatorship, I have to prove through clear and convincing medical evidence that my capacity has been restored, that something has happened, or that there's new medical evidence that relays that I truly can and will be able to make decisions myself. The standards of practice for conservators likewise apply to involuntary conservatorships, meaning my conservators still have to support my independence as much as possible and still need to ensure that my best interests are being met by decisions that are being made on my behalf. Anytime there's a conservatorship in place, there's an annual report that the conservator has to fill out saying, yes, the conservatorship is still appropriate. And I think that's it. All right. Guardianship, as I mentioned, is only for individuals that meet DDS's definition of disability, which is an IQ of 69 and below. And like I said, this is two sides of the same coin. When the court appoints a guardian, it's with the same formalities as the conservatorship, because once again, this is a taking away or relinquishment of liberty rights to make decisions myself. And so therefore, I'm going to have a marshal serve me a notice of the hearing. I'm going to have my own attorney representing my wishes at that hearing. And instead of a physician's evaluation showing by medical evidence that I don't have capacity, the court is instead going to rely upon a report by DDS saying that I have an intellectual disability and meet DDS's definition. And by virtue of my disability, the court is presuming that I do not have capacity to make decisions relative to, again, whatever the court puts in the decree. Many people have heard of plenary guardianship versus limited guardianship. Plenary simply means that any authority that the law allows a guardian to have, I'm giving to that guardian. Limited means I've found that the individual is capable of making some decisions, and so therefore they retain those decision-making powers, And those decisions in the decree belong only to the guardian. So once again, you always have to look at what that decree says, because just because somebody's a guardian doesn't mean that they have full decision-making authority across the board.
So Kathleen, question. So if that's true, why are they applying for the guardianship and why not the others that you just mentioned?
So that's a good question. I would have to say it's a case-by-case basis. In some cases, it may be that the individuals weren't aware of the other options. But in other cases, it might be that there's been a finding that that it's really important that there be some sort of legal mechanism in place to make sure that there is a layer of protection. So for example, some individuals are particularly vulnerable when it comes to specific decisions, and under the other documents, that person's decisions might still win or take precedence. So the way that they're protected is if they really don't have the authority to make these decisions themselves, but the parents or whoever is appointed is kind of serving as that shield of protection. And some decisions might be a little bit more benign or neutral than others.
Okay, thanks.
It's a good question. I think that brings us through the spectrum of decision-making relative to healthcare needs. So I'll switch over to financial, and this part of the presentation typically goes much quicker because it's basically the same spectrum of tools, but we're talking about money as opposed to health and well-being.
So before we move on, there's one question.
Oh, yes.
So let me ask that one. Okay, so can the person who is under guardianship request for a review of their ID status? For this request have to be made by an attorney on behalf of the child?
So this is somebody that's challenging the guardianship on the basis of saying that they don't think that they have an intellectual disability?
Right, yeah, I think so. Yes, it is. And I'm thinking like if that person is probably feeling that he doesn't need to be under guardianship, maybe a supported decision-making piece, and he's already got guardianship. So how do you, what can he do to get out of that pretty much? And I know it's a very hard thing to do.
Right, yeah, so it would be a process of basically becoming restored to capacity. So when the court finds that guardianship is appropriate, their findings thus based upon medical information and documentation like DDS's report, for example. If somebody feels that that report is not an accurate reflection of their abilities, my first recommendation would always be to contact the attorney that was appointed to represent them as part of the hearing, because that attorney had an understanding of the individual's wishes at the time of the hearing, and of their capacities as well. And that attorney's role is to advocate for what the individual wants, not necessarily what's in their best interest. Those two things are not always the same. The attorney really has to advocate for that individual's wishes, and to be successful, in my opinion, would need to have medical evidence or just other evidentiary proof of how the individual is really capable of making decisions. So I would probably one by one go through what the decree authorizes the guardian to do, and then come up with examples and supporting documentation showing that the individual is in fact capable of doing those things independently.
So what if this person actually hasn't seen an attorney? Because doesn't the attorney have to, don't you revisit this on a yearly basis, but I think after 2 or 3 years, the attorney is supposed to visit and speak to the individual and the guardian. Is that not true?
I believe that every couple of years there has to be a more detailed review. I apologize, I don't know that off the top of my head exactly. Some court-appointed attorneys are And it doesn't just have to be the court-appointed attorney. If the individual has resources, they could hire their own attorney. But sometimes the court-appointed attorney views their role as very singular, and that role is, I was appointed for the purpose of attending this hearing, and my representation is not ongoing. And so if that's the experience of the individual, then I would encourage them to seek out other counsel that they might have to, wouldn't be necessarily appointed to the court.
Okay, thank you so much.
You're welcome.
Okay.
So for financial decision-making, here's the spectrum of different legal planning options, starting with the power of attorney, then the supported decision-making agreement, voluntary conservatorship of estate, and involuntary conservatorship of estate, or guardianship for $10,000 or less. So you'll see here that there's a bit of a distinction with guardianship when it has to do with money. So a power of attorney is basically the counterpart to an advance directive, which was the first document we talked about for healthcare decision-making. And this is a legal document that's created by an individual that, once again, is able to understand the nature of the document. For example, that it has to do with financial decisions. And they're capable of expressing their wishes as to who makes those decisions for them. So for example, saying, I appoint my parents because I trust my parents to make financial decisions for me. I might say, is there anything you wouldn't trust your parents with in financial decision making? And if that person says, no, I trust them fully, then I feel comfortable after going through the various provisions of the document that this is an appropriate planning tool for them. So the individual is naming agents on their behalf to make decisions if they're not able. Remember, if they have a loss of capacity, a loss of consciousness, or if they simply want to invite somebody else into the decision-making process, or they want to delegate. I might say, I don't feel like managing that bank account. Can you manage that bank account for me as my power of attorney? Or as my power of attorney, can you open an ABLE account for me? Or can you get a bank statement? So you can use this document very actively and delegate those decisions, just as you can with the healthcare directive. But if I lose capacity, if that tree limb falls on me, I still have a document in place that protects my wishes, meaning the people that I appointed to make those decisions have that authority to step in and now act independently on my behalf. If I have capacity, my wishes are always going to win if there's a disagreement with my agent. Once again, a supported decision-making agreement can pertain to financial decisions. So there's not really much more to say here, aside from the fact that when an individual is creating a supported decision-making agreement, this is one of the fields that they can consider and check off. And once again, I do recommend that if someone has the capacity to create a supported decision-making agreement, they also have the capacity to create a power of attorney and a healthcare directive, in my opinion. So this is a trifecta of documents that I think individuals should have, so that even though you're naming somebody to make financial decisions for you in a supported decision-making agreement, a bank, for example, might still require a power of attorney to access certain financial records, because those financial records, the power of attorney is set forth in the Connecticut laws and actually has mandates to banks to recognize these documents. So I think it's important, not only for the recognition purpose, but also in the event of incapacity, to make sure that you have people that can still act on your behalf. Voluntary conservatorship of estate. Once again, this is now the first stop along the way where we're inviting the court or going into probate court, and I, as an individual with a disability, am saying, I don't feel ready to manage my personal finances, and so I would like a conservator to act on my behalf in managing my money. There's no limits on the money that a conservator of estate can manage, meaning that there's no upper dollar limit. It can be $5,000, it can be $5 million. the court is going to assess what's appropriate in terms of how that money will be protected. Number one, making sure that the conservator has a good background, a good financial knowledge and understanding, and the ability to undertake whatever responsibility that is. And in some cases, the court will actually also issue a bond, which means it's basically an insurance policy for the money, protecting the individual, which means that if I have $1 million that a conservator is managing for me, the court might say to my conservator, you need to get a bond for $1 million so that if you go and steal the money, the bond company is going to pay me the $1 million back, so I'm not harmed from a financial perspective. And then the bond company can go after the conservator for stealing the money. So in some cases, bond is required for somebody who's named as a conservator, but generally, if it's less than, I believe the current number is $20,000, a bond will not typically be required, though one could always be required in the court's discretion. I am voluntarily, once again, giving up my right to manage my finances. So I could also voluntarily write to the court and 30 days later regain my ability to manage my own finances. But for so long as that conservatorship is in place, if I disagree with my conservator relative to an expense or how my money is being managed, that conservator really has the final decision-making authority. Now, that being said, if there's ever any concern about the conservator, voluntary or involuntary, estate or person, acting inappropriately, I always have the ability to have a hearing, request a review with the court. I don't have to wait for an annual review. I can always ask the court to step in and look at what's going on, because that's a protection for me. Whenever anybody is managing money, they have to complete financial reports for the court. It's typically, you do one report for the first year, and then it's once every 3 years. You give a form to the court saying this is how the money was used. So there is oversight from the court as to that money. One thing that I will mention is that when assessing whether conservatorship of estate is appropriate for my clients, I look at what the income and assets are that are at issue. So if somebody only has Social Security income, I would typically say to the parent, you don't need conservatorship of estate because Social Security has named you as the representative payee, meaning you already have the legal authority to manage that money and you report to Social Security. So creating a conservatorship of estate is really creating an additional reporting requirement. And you know, I know people aren't really looking for more to do, more reporting, more boxes to check. So I try to kind of make things make sense, make sure that the finances are protected, but not over plan or make things too burdensome. Likewise, if there's money in a trust, the trustee has the authority to control that money. And so a conservatorship of estate may not be necessary under those circumstances. I want to note that I really do think I should amend this slide because it says voluntary conservatorship of estate, IQ of 70 or above. That's not a bright line rule. That is just me once again distinguishing that if you have an IQ of 70 or above, you can't have guardianship for financial decision making. But it is possible that someone with an intellectual disability, an IQ of 69 or lower, could still have the ability to voluntarily understand and appoint somebody to act on their behalf to manage their money, for money and for their person. I think that's a really important distinction. Involuntary conservatorship of estate, like involuntary conservatorship of person, is other people, i.e. my parents, saying, we don't think Kathleen has the ability to manage her money, so we're asking that the court appoint us to manage it for her. And once again, this is taking away my legal right to manage my own money, meaning that there will need to be formal process. Somebody has to give me notice of the hearing. I'll have a court-appointed attorney to represent my interests, and there must be a medical evaluation completed. From a practical perspective, the form for involuntary conservatorship of estate and person from the probate court website is the same form. It's just which parts of the form are you filling out. So somebody might only need conservatorship of estate and not conservatorship of person. They might need both. So the form is really designed to be all-inclusive, and then you choose what's important to you. I just bring that up from a practical perspective, that these, though I separate them out conceptually, are not necessarily different probate forms. Likewise, the physician's evaluation for conservatorship of person would be the same as conservatorship of estate. It's just a matter of what the medical evidence shows in terms of the individual's capabilities. The conservator's wishes win if there's a disagreement, and if I want to try to regain my autonomy and independence and financial management, I have to argue to the court that my capacity has been restored and that I really do now have the ability to make these decisions. And last but not least, we have guardianship for up to $10,000. So this was pretty recent. Within the past couple of years, our Connecticut statutes were amended to enable guardians to manage up to $10,000 for an individual with an intellectual disability to whom guardianship applies, because previously guardians didn't have any authority to manage money. And that was a point of confusion because many guardians thought they did. They thought plenary guardianship included money, but that's not the case. Or wasn't the case until the court came up with another form that said, okay, guardian, you can have the ability to manage up to $10,000. But if the individual has more than $10,000, you need to apply for conservatorship of estate, involuntary conservatorship of estate right here. So it's possible that someone with an intellectual disability has a guardian because they have an IQ of 69 or below, and that the guardian has the ability to make decisions about my personal care and welfare. But if I have $1 million, I also have a conservator of estate. So it's possible to have a guardian and a conservator of estate. And what we're really looking at is how much money is the individual, the agent, controlling on the person's behalf. Again, this is a separate probate court form aside from just the general guardianship petition. You actually have to complete a separate form. So I just let people know that sometimes they think that it's just one form. And if there's, once again, a disagreement between myself and my guardian's wishes win. If I disagree, I ultimately can petition the court to say either I think my guardians aren't doing a good job, or I believe I am restored to capacity and can make these decisions myself. So last but not least is a visual of all of these documents with their counterparts above and below the line for healthcare decisions and financial decisions. And just because somebody, let's say, has voluntary conservatorship of person doesn't mean that they might not be able to have a power of attorney as well. So you don't always have to follow the silo of the spectrum. You have to look at what's appropriate for the individual for health and well-being and financial decisions. And you might not end up at the same spot depending upon the particular individual's capacity in their particular needs. And last but not least, these are some links to some resources to get further information on the different legal resources that we've talked about. And if you have any questions, you can call me or email me. My contact information is at the bottom of the slide.